Hey, I'm Nancy Cavey, National ERISA and Individual Disability Attorney. Welcome to Winning Isn't Easy. Before we get started, I've got to give you a legal disclaimer. This podcast isn't legal advice. The Florida Bar Association says I have to say that, so I've said it. But nothing will ever prevent me from giving you an easy-to-understand overview of the disability insurance world, the games the carriers play, and what you need to know to get the disability benefits you deserve. So off we go. Now, I've done carrier-specific episodes about every major disability carrier you'll find in the United States. That being said, disability carriers are always operating with the mindset of making a profit and not providing you with the disability benefits you deserve. Today, I'm going to cover more UNUM-specific cases. Though if you're insured with another carrier, I think you're still going to find useful information here. I'm going to talk about how disability carriers like UNUM can't add eligibility requirements after the fact. Does UNUM and Paul Revere Life use quotas in denying claims? And I'll tell you the story of how one court upholds the denial of an immunocompromised UNUM policyholder and lessons you can learn. First, let's take a quick break.
Have you been robbed of your peace of mind from your disability insurance carrier? You owe it to yourself to get a copy of Robbed of Your Peace of Mind, which provides you with everything you need to know about the long-term disability claim process. Request your free copy of the book at kvlaw.com today.
Welcome back to Winning Isn't Easy. Disability carriers like UNUM can't add eligibility requirements after the fact. Now, the terms of a disability plan or a policy can't be changed by a disability carrier or a plan after the fact. Let me give you an example of what UNUM tried to do in the case of Jalal versus UNUM Life. This is a case out of the Southern District of Ohio. The UNUM long-term disability policy defined total disability as requiring the claimant to be unable to perform the material and substantial duties of their regular occupation due to sickness or injury. Then, after 24 months, the definition of disability changed from an inability to do one's own occupation to an inability to do any occupation. And the policy said to be entitled to those benefits, the claimant had to be unable to perform the duties of any gainful occupation for which the claimant was reasonably fitted by virtue of their education, training, or experience. Now, there was no reasonable accommodation provision in this definition. Yet, UNUM said, oh, wait a second, we're going to deny these benefits on the basis that she could perform work on a sit-stand basis that would accommodate her restrictions and limitations. You didn't hear that word in either of those definitions, did you? So, in determining the ability to do any gainful occupation, can a disability carrier consider reasonable accommodations? Well, I would say to you, generally the answer is no, unless there's a specific provision in the policy or the plan. Now, in this case, Dr. Jalal argued to the federal court that UNUM had misinterpreted the plan when it determined she was no longer totally disabled because a hypothetical employer could accommodate a sit and stand option. So sit, stand, alternate position. As I said, the definition of disability did not have a reasonable accommodation requirement. But what UNUM said is, look, we're going to use a gainful occupation analysis. And using that type of an analysis, an administrator could consider a reasonable accommodation, even if the plan was silent. Now, the court fortunately ruled that the contractual terms of the plan or policy should be enforced as written. And once the plan is established or the policy is written, the administrator's duty is to see that the plan is maintained pursuant to that instrument. To the degree that a disability plan or policy terms are ambiguous, then any ambiguity is to be resolved in the policyholder's favor. Now, as I've said, when we look at the definition of disability in this particular UNUM plan, there was no reasonable accommodation language as part of the definition. And the court said, look, this was really clear. The plan's silent and it doesn't allow for consideration of a reasonable accommodation. And UNUM can't unilaterally rewrite a plan and apply a standard of disability that doesn't exist. As a result, the judge awarded benefits and determined that Dr. Jalal met the plan's definition of disability. Now, That was a fantastic win. And in fact, this is the third time she's beaten UNUM because it's the third time UNUM has denied the claim. Hopefully UNUM gets the message, but congratulations to Dr. Jalal and her lawyer for taking on UNUM. Ready for a break? I'll be back in a second.